Welcome to Dali Talk. This is Dali. How is everybody doing? Hey, Scott, how are you? Johnny, Brad, Justin, I was not late. Oh, maybe I was. 1 minute. So, could be worse. All right. So, what are we doing today? Just going to be fairly quick. Um, the lovely Lori finally found out that one of the jurors was did an interview, and on this interview, they let slip that they supposedly knew about her previous convictions the day before they convicted her. Hey Jay, how are you doing? So Lori wrote a motion um, for a new trial. So we're gonna go through that today. And Lori also has the second trial coming up at the beginning of June for Brandon Boudreaux. Um, so that's going to be interesting. We got to do all this over again. So let's see. Let's see. Okay. Oh, hey, half Irish. How are you? Sorry, guys. Let me represent this. Had it set up, but oh well. There we go. Not surprised they knew. I'm kind of surprised they were dumb enough to say they knew. And he sounded really articulate up until that point. Um, so he kind of stepped in it. And yeah, somebody else got this document. I could have got it too, but I didn't feel like paying $5, $10 to get it. So, all right. What do we got? Memorandum of points and authorities. So this is Lori coming in hot, lovely Lori, requesting that she get a new trial. I know there's a watermark. It's not original. I know. It must be fraudulent. We'll need a Frank's hearing. Um, so on April 28th, it came to the attention of this defendant's advisory council, and later the court, um, that Juror 15 made a statement indicating he had knowledge of this defendant's prior conviction. Who is Joe Schmo? He was someone there. Is he a hoe? He was with the media, I think. But he would go on Trial TV, Trial Tube, another YouTube channel. He was reporting for them. So he got this. Okay. So, damn it. He also indicated that he was leaning towards a not guilty vote up until yesterday and through deliberations. Um, yeah, he's alive now. This prior conviction involved the homicide of her children in Idaho in 2023. This defendant did not testify in this trial, and this conviction was not presented by the state. Hey, Maddie. As Rule 404B Other Act evidence. Thus, Juror 15 should not have learned about this information. Uh, I also remember on April 8th. God, why am I yawning? Sorry. Excuse me. One day at work. Um, April 8th, there was a juror who was pulled aside and questioned by the judge because he happened to be texting somebody or playing Candy Crush or Pokemon Go. I'm not sure, but he was on his cell phone. Um, I'm I haven't confirmed, but I'm saw somebody else mention that Juror 15 was a problem before, so I'm speculating that this was the texting juror. Yeah, the judge and all the parties had to like, well, were you looking up anything? They were concerned he was looking up something on the case. And yeah, it was all awkward. God damn. Sorry, guys. And he yeah, got kind of scolded. I mean, I don't blame him, but so this defendant did not testify in the trial, and this conviction was not presented by state as Rule 404B Other Act evidence. Thus, Juror 15 should not have learned about this information. Oh, should have promoted it to the judge looking up my Discord. That'd be amazing. Really kind of disappointed that, like, no mention of Dali Talk made it into this. Could have even interviewed the jurors. Because this case was a high profile matter, once the jury was released from its admonition, jurors were free to speak with media. During an interview, Juror 15 was asked about his reaction upon learning about this defendant's prior conviction. He stated the following: "You know, I feel sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell." Well, true. Oh, sorry, guys. Um, she is. So, not lying there. Unfortunately, he wasn't supposed to know that information quite yet. So, that was the main one for the jury. Um, yeah, don't murder your kids. Apparently, the government and just society at large frowns upon that. Uh, she also included some other uh, issues she had at the trial. So she went and threw them in this motion just to preserve the record. Was that all he said? Um, I believe she mentioned something else later. We'll get to that. Um, Preclusion. So B. This is a new one. Preclusion of Tylee Ryan and Alex Cox statements and impermissible expert testimony by Detective Daniel Coons. Ooh, okay. Prior to trial, the court concluded, or the court precluded this defendant from presenting to the jury any of Tilly Ryan or Alex Cox's statements. So Tylee Ryan was her daughter, who's like 16, I think, 15. And Alex Cox's was her lovely brother who unalived her husband. Both of these people were present during the shooting of Charles Vallow, and thus some of their statements were not hearsay. God, why am I yawning? I'm not really that tired. Oh, God, sorry guys. Okay. Hi Tracy, how you doing? We are just going over the new motion for Lori Vallow and why she wants a new trial. So both of these people were present during the shooting of Charles Vallow. Sorry, half Irish. Um, and thus some of their statements were not hearsay as they show effect on listener pursuant to Arizona Rules of Evidence 8033. The state filed a motion in limine throwing a blanket hearsay objection over the entire statements. So both of these people were present during the shooting of Charles Vallow. Did she make this argument to the judge though? Yeah, it would have been a pretrial thing. So she's just doing the official, you gotta say why you want a new trial to put everything on the record for the appellate court. I mean, I'm sure he's going to deny it, but okay. The court indicated in a pretrial ruling that it would at least to Alex Cox's statement, take it on a statement by I'm sorry, guys. I'm like really distracted because my TV is my second monitor and it keeps like randomly flashing. And it's like everything is just messing up today. My God. During trial, this defendant was precluded from even discussing that Alex conducted a walkthrough, much less his statements with Chandler PD during that walkthrough. Yeah, she should file for ineffective assistance of counsel. Yeah, Lori must have done something with it. It's possessed. Then, in the stats case in chief, it elicited expert testimony from the scene agent, Detective Daniel Coons. Oh, what an offensive last name. This defendant objected to his testimony as an expert witness based on lack of foundation and her not having had time to rebut his professional opinion. Again, this defendant was precluded from discussing Alex Cox's, the shooter, walkthrough that was conducted with several Chandler PD, including Detective Coons. This walkthrough was precluded as inadmissible hearsay. However, it formed the basis for Detective Coons' questioning with the medical examiner and how he then investigated this case, as Alex Cox indicated he shot the victim in self-defense. It's kind of a weaker argument, but okay. So, we got a discovery violation. On April 14th, during trial, Miss Trina K. Pretty sure it's Mrs. But Miss Trina K produced a hard drive containing the gray key. Ooh, my. Information for Charles Vallow's cell phone. The contents of the hard drive are exculpatory evidence. Defense had been requesting this evidence so that she could prove it to her independent expert for his review. This discovery disclosure occurred in the middle of trial. So there was something that happened. She wanted her expert to go over some cell phone data, but like there wasn't enough time to get it all done um thoroughly and turn it over to Miss Trina. So the judge kind of kicked that evidence out. Uh Probably the right call, although I mean, you kind of want to give her a little leeway, I would think, just so you don't have this kind of crap on the record. Oh, yeah, yeah, yeah. She wanted a speedy trial. Uh, she didn't want to waive that, so okay. Yes. Yeah, the $200 bamboo shirt that does all kinds of damage to the floor, apparently. On April 8th, 2025, the state elicited irrelevant, prejudicial, and improper character evidence when she asked Chandler Fire Captain Keller if he overheard any conversations with this defendant. She was warned several times about the speedy trial. Well, she was. In her defense, it did work to her advantage in the first trial. Um, Hey, Ariel. So, well, she says it occurred. Wait, why did it take so long for Trina to produce the gray key info? It was produced like a month before trial. So I don't know why she says in the middle of trial. Um, but yeah, with the refusing to waive her speedy trial issues, it kind of really hurt her mostly. I mean, it did work, in Idaho and got the DP tossed for her. So she was trying to use the same technique in Arizona, but she got kind of lucky in Idaho. So Miss Trina K asked Captain Helen Keller on direct examination, "Did you overhear this defendant talking with police?" Yes, she did, and she got one. She didn't want to wait because she don't like it where she is and wants to go back home. Has to be hyperbolic, yeah. Yeah, so far the first argument is the strongest. Good on her putting her best stuff first, I guess. Yeah, that's the only one that kind of moves so far that moves the needle a little bit. Not much, I don't think, but hey, Moni, how are you doing? Uh, he responded in the affirmative, stating he overheard someone stating not getting invited to pool party because of the commotion at the house or something. Oh my God. Lori was not getting invited to the pool party. Well, case closed, guys. Lori's getting a new trial. I'll give Lori credit for writing logical motions. I do wonder how much her advisory council is doing the writing for these motions. Because this is at least very well formatted. You got the columns and everything all lined up. Um, you got, each side is all just nice and pretty. You don't have like words, going off a little bit on the side. It's a damn good document, a damn good motion. I mean, Sean would be impressed. I'm impressed. Sarah Boone could learn a thing or two. Yeah, nobody wanted her green chili chicken enchiladas. I swear, if we don't find out that recipe in the next trial, I'm going to be so mad. Suffer Sarah. Apparently, there's some family court drama going on with Sarah Boone that I haven't really looked at. I'm just. I should write her and ask her for a letter, or write her a letter and ask her for the recipe. Yeah, somebody needs to preserve it. Apparently, her family wasn't too thrilled with it. Somebody needs to appreciate it. Okay. Come here, kitty. All right. Kitty. So, okay. Um, this statement caught this defendant off guard as Captain Keller indicated during his interviews with Chandler police just after this incident occurred that he only saw the male outside on the curve and did not mention ever seeing this defendant. No pool party had been sent or mentioned. During closing arguments while addressing the justification defenses, Miss Trina Kay told the jury that this defendant was not entitled to any pool party. I mean, any of these self-defense instructions. Miss Trina Kay also gave false statements by saying Alex had no reason to be at this defendant's home. Well, Alex is her brother, and they're very close. Um, some would describe it as an Alabama type closeness. Um, but and that this defendant told Alex to bring a gun. Uh, Miss Trina Kay knew from previous testimony interviews and pretrial defense interviews that Summer had begged Alex to go over to this defendant's home because of Summer's concerns for this defendant's safety. Finally, Miss Trina Kay commented, well, yes, that's sweetie. Okay. Miss Trina Kay also gave false statements by saying Alex had no reason to be at this defendant's home and that this defendant told Alex to bring a gun. Miss Trina Kay knew from previous testimony, interviews, and pretrial interviews that Summer had begged Alex to go over to this defendant's home because Summer's concerned for this defendant's safety. Okay, Princess. Oh, there you go, Junior. Okay, Lori, Princess. That's why they call this a closing argument. She's allowed to argue what the facts of the case mean. No, I'm not a fan of prosecutors myself, but she just did her job there. Really want the green chili chicken enchilada recipe too, right? God. It would be funny if it actually is really crap. Alabama closeness. Well, it was either that or a Game of Thrones reference. Okay, what do we got? Miss Trina Kay commented several times on this defendant's demeanor during this incident drive to police station on the body cam and told the jury, you did not see her cry in that interview. Yet knowing there were portions of the defendant's interview that had been cut from the full interview admitted by the state where she sat in the room and did show emotion. and can be seen grabbing a Kleenex. Oh my God. She blew her nose, not guilty. Colby said it was not very nice at all. She's probably that one family member that thinks they have a really amazing dish, and it just everybody in the family just doesn't want to hurt their feelings and say, no, it's actually garbage. Oh, now she's throwing shade at the judge. The court precluded this defendant from presenting a defense by striking her witnesses, including but not limited to that dickhead Nate Eaton and Bobby Boucher. I mean, Brandon Boudreaux, before they were even called to the stand. Specifically, before testimony began, the court required the defendant to establish on the record what relevancy her witness would present. Well, that is true. That did happen. Personally, I think it would have been funny as hell if Nate Eaton had to be called as a witness. But that's just because I like chaos, and that would have been funny as hell. I don't know why the hell she wanted Brandon. You know, he's going to be at the second. He is the attempted murder for the second trial. Why she wanted him, I don't know, but okay. And I was really surprised she didn't try to. And the judge even said, "Okay, well, I'm not going to let you have them on your witness list for now, but when it comes to your case in chief, if you can connect the dots and find some relevance for them, I'll reconsider." And she never even tried. This required this defendant to state in front of the prosecutor her defense strategy. This is not required under the law or any rule of evidence. Well, Princess, you go from case strategy or just a reason for calling the witness. You don't have to say what the entire every question for question you're going to ask, but you need to let the other side know this guy's going to be talking about this or this guy's going to be talking about that. You know, this guy's an expert in bamboo shirts. This guy knows a lot about, knockoff wish.com bamboo shirts and how they affect hardwood flooring. Hey, Schnivels. I mean, Lori, I'm giving you the benefit of the doubt here, but you gotta put in the work. During cross-examination of a civilian witness, Serena Sharp, in relation to testimony regarding religious beliefs. Oh, we got a typo. We got a typo. Religious beliefs. That would be religious beliefs. Unless that's just a Mormon thing, and I'm mistaken, but okay. Oof. The court commented during the prosecutor's objection to relevancy, stating, "I guess to the extent that you are comparing yourself to these biblical figures, I will allow it." Part of the state's case was to establish that this defendant had stepped outside of the Mormon religion by claiming she was a translated being. Suffa Joseph Smith. Specifically in text messages saying she would be like Nephi and that these messages were nothing more than part of the conspiracy to kill Charles Vallow. This defendant attempted a trans what? A translated being. Uh, this defendant attempted to establish that being translated was a regular part of the Mormon religion and thus a relevant line of questioning. Um, okay. The only wacky thing I know of about Mormons currently is they don't like Diet Coke. So they don't really even do the polygamy thing anymore. So, okay, but translated being's a little far fetched for me. So, oh, what the hell are we up to? Okay, so getting through this. So now we're going to be argument and authority. Like Google translated. She's more like Ask Jeeves translated. The Arizona rules of criminal procedure provide that a court may grant a new trial when a juror or jurors have committed misconduct by receiving evidence not properly admitted during the trial. Additionally, a new trial is appropriate if, for any other reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial. Right. I think we can just zoom in here. Right. Appropriate if for any other reason not due to the defendant's own fault. Okay. Okay. So now she's arguing about the jury thing. This defendant is entitled. Oh, it keeps going. I'm sorry. To a new trial because the jury received and consulted extraneous information. Well, the only thing okay. Once a defendant shows the jury received and consulted extraneous information, prejudice must be presumed, and a new trial must be granted unless the state proves beyond a reasonable doubt the information did not taint the verdict. Absolutely, unless you know you're Murdaugh. In State v. Poland. Oh man, judge and prosecutor had to save her so many times from kicking the door open, right? Oh, that would have been amazing if she did, though. The court held that since the federal convictions were based on the same series of acts as were at issue in the state prosecution, evidence of the prior conviction is inherently prejudicial. When a juror does not base his verdict on evidence developed at trial, he violates the fundamental integrity of all that is embraced in the constitutional concept of trial by jury. It's a 1988 case. I would have thought they kind of developed that before then, but okay. Such misconduct by jury members denies criminal defendants their right under the 6th and 14th Amendment to confront and cross-examine his accusers about that extrinsic evidence. Oh boy, I expect to see Lori complaining her 19th Amendment rights are violated pretty soon. This defendant's advisory council and the court both received evidence that the jury's verdict was tainted. Boy, I really should have waited for Hella to get up. When Juror 15 spoke during his interview with Fox 10 News, Suffa Fox 10 News, disclosing that he had learned of her prior convictions seemingly one day prior to the admonition being lifted. Because it is clear Juror 15 had information he was not entitled to know. Prior to conducting deliberations, the burden is on the state to prove, beyond a reasonable doubt, that this information did not taint the verdict. The state will not be able to meet this burden, and the defendant is entitled. Oh, to a new trial. Okay. Kept going. Even if an offending juror may not have influenced the other jurors, unanimity is required to convict a criminal defendant. And the juror's conclusion may have been different had the juror not consulted extraneous sources. State v. Cornell. In Cornell, a juror looked up definitions that were neither. Let's see. Karen Reed can't get her case tossed. I'm not going to hold my breath waiting for Lori's case to be tossed. She's comic fodder at this point. Oh, yeah. It's a very high bar. I mean, hell, even Murdaugh up to this point didn't get a new trial. And a juror admitted that their conviction, or their saying guilty, was influenced by Miss Becky Hill. Sweet, sweet Becky Hill. I don't know how many of you guys have followed that case, and Murdaugh is garbage and stole from everybody and their mother. He literally stole from orphans. Literally. He stole from the kids of a woman who died on his property that worked for him. I don't know if he murdered his wife and son, though. But regardless, I mean, he didn't really get a fair trial. But they're still having to fight just for that to be heard. So, I mean, Lori's, she's not going to get one. Karen Reed, hopefully, is found not guilty, because dealing with the appellate court is a nightmare. Okay, so in Cornell, a juror looked up definitions that were neither admitted into evidence nor included in the trial court's instructions. The juror testified that he was confused and undecided about the allegations, and his reference to outside sources made his decision that the defendant was guilty. Reference to dictionary definitions by jurors is usually considered a harmless error. However, the appellate court found that this was not a harmless error, and that the defendant was entitled to a new trial. Similar to the juror in Cornell, Juror 15 stated he had information neither admitted into evidence nor included in the trial court's instructions. Even more egregious than in Cornell was that this information learned was that this defendant had prior homicide convictions, as in Poland. This information is inherently prejudicial, as these prior convictions directly related to this prosecution. At the time of the writing of this motion, it is not known if Juror 15 shared this information with other jurors. I will be interested to see if the judge ends up calling the jury back to question them and how in depth those questions would be. I bet Miss Becky would do anything to not have had her 10 minutes of fame. Oh, yeah. Um, they're very concerned Murdaugh will get a new trial, and having Miss Becky Hill hanging over that was the new trial it'll be very interesting. I thought the judge handled Lori so well in court. Absolutely. The only slight criticism is I didn't like the judge really just not being a little he could have been more flexible with allowing Lori to call the witnesses she wanted. I don't think it'll matter in the end, but eh, it's just it's kind of there's a slight chance it could be an issue. Uh, these actions directly violated the court's instructions and could have factored into Juror 15's verdict, if not multiple jurors' verdicts. In fact, Juror 15 noted that up until the day of closing arguments, he would have voted not guilty. I mean, yeah, until he gets in the room with 10 or 11 other people screaming, "What are you, an idiot?" It's so effing obvious. You know, a lot of that stuff can go on in the jury room. But anyways, given this, the state is unable to prove that Jurors 15's misconduct did not taint his and potentially other jury members' verdicts. The state will not be able to overcome the overwhelming evidence of Juror 15's misconduct in order to prove beyond a reasonable doubt that Juror 15's misconduct did not taint the jury. Taint. Accordingly, this defendant is entitled to a new trial. You can't just call random people to the stand with no chance for the other side to prep. Oh, I know, but yeah, I don't think a lot of our witnesses would have needed a lot of preparation. So now this is the argument for preclusion of Tylee and Alex's statements. A new trial is appropriate if for any other reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial. Sorry, what was Juror 15's misconduct? Yeah, I don't know if misconduct. Sorry. Um, I don't know if misconduct would be the right word. Unless he was like going out and searching it up on his own. I mean, if he's standing in the lunch line and overhears somebody saying that, I wouldn't. I don't know what. I mean, he'd have been tainted, but that wouldn't like be his fault necessarily. Um, the court made a pretrial ruling that at least Alex Cox's statements, it would make a statement by statement ruling. Instead, this defendant was even precluded from discussing Alex Cox's statements during his walkthrough. Well, this defendant was even discussing Alex Cox's statements during his walkthrough because he's not a party opponent. So you wouldn't be able to bring his statements in unless there's some other kind of exception, like excited utterance or, well, there's a lot of hearsay um, exceptions, but I can't. No, I mean, that's the right ruling. These walkthrough statements formed the basis for Detective Coons being able to testify as an expert, yet she was precluded from cross examining him on this foundation. That sounds like it might just be you couldn't figure out how to ask the right questions there. So then we got C. Defendant or discovery violation that occurred in the middle of trial. Entitle this defendant to a new trial. Discovery rules are designated to implement and not impede the fair and speedy trial rights. Discovery rules are designed to implement and not impede the fair and speedy trial. I'm not sure why she had to throw in speedy trial rights there. They're just okay. On April 14th, during trial, Miss Trina Kay produced a hard drive containing the gray key information for Charles Vallow cell phone. Maybe that was something else. Because she wanted the cell phone to be examined. Oh, maybe she's just rehashing that objection. The contents of the hard drive are exculpatory evidence. Defense had been requesting this evidence so that she could provide it to her independent. Independent what? Defense has been requesting this evidence so that she could provide it to her independent. She doesn't say. Oh no! I wonder what she meant. The state's discovery violation is one, the importance of the evidence which the defendant was deprived cross-examination, the right to confrontation and proper investigation and examination for defense. I know, independent expert, okay. I just find it funny that she left that off. The state manifested the surprise and prejudice to the opposing party. The violation was motivated by bad faith. Bad, Trina, bad. Which neither the court nor the state corrected, and for the many other relevant factors that the state saw fit to depriving the defendant of her constitutional and statutory rights. Oh no. Oh, poor Trina. Well, good Lord, she acts like this is Jodi Arias' prosecutor. Trina was very tame. She almost got her dad in, but the reporter guy Nate would have been a complete waste of time. Yeah, but it would have been funny as hell. Hey, Melissa, how you doing? Alrighty, so the statement elicited from Captain Keller was irrelevant and prejudicial to this defendant. Yet Miss Trina Kay purposefully asked this witness if he overheard any statements. Miss Trina K purposefully asked this witness if he overheard any statements. That's okay. Can't get into what they are. Second, it is improper for a prosecutor to misstate the law or evidence during closing arguments. Well, oh, whoa, 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 whoa. You know, Princess, that's where we get into you needing to object. You know, Miss Trina K had no problem hitting that objection, but you were a little meek mouse. And a lot of these might be just considered waived. No matter how much you sigh before court starts. Second, it is improper for a prosecutor to misstate the law or evidence during closing arguments. Miss Trina K stated this defendant was not entitled to self-defense instructions, yet they were clearly provided to the jury. Okay, that would be a good thing then. It makes the prosecutor look bad. But I don't even think that's what was said. Miss Trina K also gave false statements in her closing argument. Of course she did. By stating Alex had no reason to be at this defendant's home and that this defendant told him to bring a gun and extra ammo. Yeah, I mean, again, you needed to have objected. I remember even being like, what are you doing? I even remember when Miss Trina said that, and I could not remember, unless I'm mistaken, maybe I am, but I do not remember any evidence that Lori asked Alex to bring a gun over. So, okay, that could be facts not in evidence. You need to object or you waive the issue. That's kind of the biggest reason why you probably don't want to represent yourself. What Lori doesn't understand is court is for facts and evidence, not story time. Yep. And there's a very high bar for what evidence is able to come into a court for probably the right reasons. I mean, debates on the role of evidence aside, what it is right now, yeah, needed she can't just speculate or just want and get her way. It can't be hearsay. There's certain rules, and she just really didn't articulate her arguments very well either. She was very nonchalant in a representation of herself, quite frankly. Miss Trina K knew from previous testimony interviews and pretrial defense interviews. That Summer had begged Alex to go over to this defendant's home because of Summer's concern for this defendant's safety. Lastly, commenting on this defendant's demeanor, specifically stating this defendant did not cry during a police interview, was improper comment, as she had cut this portion out of the exhibit, stating that she called a full interview. All of these comments add up to prosecutorial misconduct. I would argue that goes to an issue with the judge and what he allowed or didn't allow. But yeah, it was just a ruling the court made. And then lastly, judge commenting on the evidence during this defendant's cross-examination showed a lack of impartiality and entitles this defendant to a new trial. Okay. Rule 15.2b of the Arizona Rule of Criminal Procedure requires a defendant to disclose for each listed defense other than the defendant that the defendant intends to call a witness at trial in support of the defense. Um, it requires a defendant list the name and address of each person. Well, probably don't want. Oh yeah, there was an issue. There was an issue I remember with her sending one or two subpoenas to one of the family members, and it was almost considered harassment. Are we reading your love letter to Lori? Um, no, that'll be on the next stream. The defendant intends to um there is nothing in Rule 15.2 that requires this defendant to present her defense strategy in order to oh god, this again. In order to call witnesses. Again, you're not princess. You're not giving away your strategy in letting the court know why you want to call somebody. The Fifth Amendment of the United States Constitution provides this defendant the right to subpoena power. Oh, yeah. This preclusion of witnesses and requirement of this defendant is to inform the state of her defense prior to calling any properly noticed witness shows a specific claim of partiality. Oh. Huh. Okay.
I doubt it.
Second, for the record, established, or for second, for the record established that the court commented while responding to the state's relevant objection, and the comment showed a specific claim of partiality by casting doubt onto this defendant's credibility on this religious issue, and in general showing she cannot be trusted. Wait. The court commented to a relevancy objection, I guess, to the extent that you're comparing yourself to these biblical figures, I will allow it. Guys, also, David's in chat. He is doing a Lego stream later. So make sure you check that out. I will try and redirect over there when I finish in a few minutes. I'll set that up right now. Sorry, guys. Let's see. Oh, there it is. Okay. Okay. All right. So we're almost done. As seen as injecting his own, thank you, Half Irish. Yes, there's the link. Much appreciated. Injecting his own opinions as to this defendant's reliability during her cross-examination. Okay. This comment is even more important when taken into consideration that Juror 15 in the Fox News 10 clip indicated he ultimately made a decision to vote guilty based to text message. To vote guilty based to text message. Okay. Including the one describing, I will be like Nephi. The court inserted, ooh, my, his own improper comment when a simple overruled or sustained was warranted. This in and of itself shows a lack of impartiality and requires a new trial. Well, there we go. It's a bold strategy, Cotton. I yeah, insertion. I know. Pretty sure this judge is also Mormon too, so I mean, he's probably not a fan of the way you're kind of using the Mormon religion, I will say that. Yeah, I'd focus on Juror 15 argument. It's about all you got. But we got the Bobby Boucher trial coming up soon, so that'll be fun. All right. I am gonna end it here. David, I'm gonna redirect over there. But I believe Sean said David's going at 6, I believe, or 9 Eastern, with the recovery addict. And then Sean I think said he was gonna be streaming again at 6. I don't think he set it up yet, but I could be mistaken. So check that out as well. Boudreaux, not Boucher. So he's not the water boy? Hmm. Laura Vallow is the devil. All right, guys, I'm going to end it here. It's been a lot of fun. Hella, I don't think is going to stream later, but she may. Something may pop up. And she probably will do a melody stream tomorrow, but we shall see. It's been a lot of fun, guys, and I shall see y'all later. Godspeed.